Hello, everybody. Welcome to the second in a series of online events called RefMig Meets the Author. As you know, the RefMig project is an ERC individual project that I lead based at the Refugee Study Centre in Oxford and the Centre for Fundamental Rights at the Hertie School in Berlin. Our first session was with the author, Dr. Lamis Abdelati, and today I'm really delighted to welcome Professor Hilary Evans-Cameron to discuss her 2018 book, Refugee Law's Fact-Finding Crisis, Truth, Risk, and the Wrong Mistake. This is a wonderful book, as you're going to learn, and for any scholars of refugee law or refugee activists out there, this is really a must-read work in terms of identifying a central issue and problem, indeed, as she calls it, a crisis, in refugee law in practice, and offering some practical solutions that are based in a very deep legal analysis of the problem that bedevils refugee adjudication. Hilary is herself currently assistant professor at the Lincoln Alexander School of Law at Ryerson University in Canada, but she's also a former litigator who for over a decade assisted refugee claimants in the asylum process in Canada. The book is based on her doctorate at the University of Toronto, and she's also the author of several other important works on these topics that have appeared in leading journals. To discuss the book with me today, I'm delighted to welcome Professor Gregor Noll. Many of you know his work already. He is Professor of International Law and the current holder of the Torsten Soderberg Research Chair at the School of Business, Economics and Law at the University of Gothenburg in Sweden. His expertise spans wide and deep across diverse areas of public international law, but focusing on the topics of today's discussion, he's the author of the chapter on credibility, reliability, and evidential assessment in the Oxford Handbook of International Refugee Law, which appeared this year, which I had the honor of co-editing with Michelle Foster and Jane McAdam. He's also the editor of an important collection, Proof, Evidentiary Assessment and Credibility in Asylum Procedures, from 2005, and for my money, still the best monograph on the European asylum system, negotiating asylum, the EU acquis, extraterritorial protection, and the common market of deflection, which appeared in 2000. So Gregor, I know you also enjoyed this book greatly, so I'm looking forward to your discussion. But first of all, we're going to turn to Hilary, who's going to present the arguments in the book to us. So thank you. Over to you, Hilary.
Thank you so much, Cathryn, and thank you so much for this invitation. It is such an honor, and it is such an honor to get to speak with Gregor on this topic. Here in a fairly large nutshell is the central argument that I make in this book. That famous image of Lady Justice with her blindfold and her nicely balanced scales. I think that misleads us. I think it gives us the impression that legal decision makers are supposed to be neutral, impartial. A legal decision maker can never be impartial. They could if they decided by flipping a coin. But if they're going to use their judgment in a courtroom, in a hearing room, or frankly, even just in real life, two questions will come up in every case that force them to pick a side, by forcing them to choose who should pay the price for their uncertainty and who should benefit from it. The first question is, how certain does a decision maker need to be before they accept an allegation as true? The second question is, what should they do if they're on the fence, if they can't decide whether they're certain enough? And in some cases, a third question will come up, which is, what should they do if they think they know ahead of time that certain kinds of allegations are very likely to be true or untrue? Should they take these prior probabilities into account? The answers to these questions will make it easier or harder for an allegation to prove itself. So the decision maker will answer them differently depending on how they feel about the two kinds of potential mistake that hang in the balance. Should they make it easier for an allegation to prove itself and err on the side of accepting more false allegations? Or should they make it harder and err on the side of rejecting more true allegations? Which kind of mistake is worse? If every decision maker could decide for themselves in any case for any reason how they would prefer to err, this would be a recipe for inconsistent, arbitrary judgments. So making clear to decision makers how they should resolve their doubts is the sole express purpose of the law of fact-finding. Those three questions, the law answers them with three legal structures: the standards of proof, how certain should I have to be, burdens of proof, the law's tiebreakers, and presumptions, what can I go in assuming for the sake of argument. Burdens of proof, standards of proof, presumptions together create the obstacle course that an allegation has to run on its way to the finish line of being accepted as fact. And the people who create law will design that obstacle course to make it more or less challenging, depending on whether and to what extent they want that allegation to pay the price for the decision maker's uncertainty. Blackstone's maxim is one of the most famous ideas in the Anglo-American common law. It's the idea that in a criminal trial, it is better that 10 guilty persons go free than one innocent one be convicted. The architects of our criminal law, back through the ages, had a strong theoretical preference for resolving doubt in favor of the accused. So while our courts, our justice systems, in fact, treat any number of accused very badly and some worse than others, within a criminal trial, the legal obstacle course is designed to make the accused's job easier than the prosecution's. So the state has the burden of proof, the standard of proof is very high, proof beyond a reasonable doubt, and many presumptions favor an accused, few favor the prosecution. The combined effect of these rules is supposed to constrain how judges and juries manage the risk of error. Right? How effective that constraint is of course, another question. What's the wrong kind of mistake in refugee status decision making? Is it worse to deny a claim that should have been granted or to grant a claim that should have been denied? In the book, I look at some 1700 judgments of our federal court, which reviews our first instance refugee board decisions. And what I saw is that our court disagrees with itself on virtually every question relating to the design of the obstacle course, how the burdens of proof, standards of proof, presumptions should operate. Because in the absence of a clear answer in international law, our court disagrees with itself about what the wrong mistake is. We have one body of judgments that suggests that it's better to avoid mistaken rejections, another that suggests that it's better to avoid mistaken grants. And each has designed its own obstacle course. One that resolves doubt in the claimant's favor, the other that resolves doubt at the claimant's expense. And what this means in practice is that our refugee board members can decide in any case, for any reason, which obstacle course they would rather have the claimant run, which allows them to say on the same facts, either, I'm in doubt, so I'll accept you, or I'm in doubt, so I'll reject you. My colleague Sean Rehag has long documented the wide disparities in our refugee board members' grant rates. At times, for similar claims, we have some members who've rejected every single claim they've heard and some who've accepted every single claim. I don't think that's surprising. On the contrary, I think it would be surprising if our board's decisions were any more consistent than the law that's governing them. So in the book, what I suggest is that to move forward, we have to recognize, first of all, that by law, and I make some legal arguments about this that I'm happy to talk about in discussion if it's interesting, but by law, it is a worse mistake to grant a claim that should have been, rather, to deny a claim that should have been granted. It is a worse mistake to deny a claim that should have been granted than to grant one that should have been denied. And more fundamentally, we need to rethink the role that fact-finding plays in the refugee law context. And so this is the book's concluding argument. As it stands in Canada, board members have two fundamentally incompatible mandates. Because on the one hand, they are supposed to be assessing the risk that the claimant faces. That is their job under the convention. On the other hand, they're supposed to be making legal findings of fact under the Canadian refugee system. The logic of risk assessment and the logic of this kind of legal fact-finding in the Anglo-American common law tradition work very differently. Our legal tradition is built on inductive inference. So in a refugee hearing, an allegation will be accepted as fact if and only if the decision maker finds that it's probably true. So probably true equals true. And as a first step, decision makers have to make findings of fact. They have to turn all of their relevant doubts into certainty before they then move on to make legal findings based on those facts. Risk assessment, on the other hand, is not a fact-finding process. There's never any point at which doubt becomes certainty. In a risk assessment, all doubt carries forward into the final weighing of potential outcomes. So I'll give you an example of the difference. If you're imagining that you're walking in the woods picking mushrooms, you pick a wild mushroom, and you're asking yourself, is this mushroom safe to eat? You think it's probably a chanterelle, and you're quite certain that chanterelles are edible. Should you eat this mushroom? If you're using legal reasoning, bon appétit. Right? You can eat the mushroom without a second thought. It's probably a chanterelle, so it is a chanterelle. That's now a fact. And you're quite certain that chanterelles aren't dangerous. If you're using risk assessment logic, you're going to be saying, oh, hold on, it's probably a chanterelle, but how probably? 51% probably, 99% probably? It makes a difference. If I'm worried about my risk exposure, my level of certainty makes a difference. And this is why you can't assess risk if you make findings of fact. An inductive fact-finding model distorts risk assessment. So what I suggest that we should be using instead is a different kind of reasoning, abduction, which is generally equated with a mode of analysis called inference to the best explanation. So in induction, we draw a conclusion because it probably follows. Deduction, we draw a conclusion because it follows by logical operation. In abductive reasoning, we draw a conclusion because it's plausible enough and it's the best answer that we can come up with under the circumstances. An abductive inference, in other words, is an intelligent guess. And what I suggest in the book, in another nutshell, is that decision makers should be looking to identify the best explanation for the evidence before them. And in this process, to give effect to that legal requirement to resolve doubt in the claimant's favor, the claimant's explanation, her theory of the case, should be accepted unless a counter theory is decidedly more persuasive. So to conclude, the title of the book has a hidden meaning: Refugee Law's Fact-Finding Crisis. Refugee law is in crisis not only because of how decision makers are making their findings of fact, but simply because they are making them. It is too dangerous. It's safe enough. Eating this mushroom would be foolish. The claimant's fear is not well founded. These are statements of opinion, not statements of fact. Decision makers may, of course, feel certain about many things, but to make a decision, they don't need to be certain about anything. And frankly, if for no other reason, making decisions that are framed in the language of uncertainty and risk assessment rather than framed in the language of fact has the secondary benefit of not being gratuitously insulting. I think on a human level, there's a world of difference between I have serious doubts about whether you were assaulted and I find as a matter of fact that you were not assaulted. Why do we have to pretend that we know more than we do? One of my favorite scholars, Audrey Macklin, has used this wonderful phrase, radical uncertainty, to describe the context in a refugee hearing, radically uncertain. In a context like this one, where we know that we're going to get it wrong a lot, turning doubt into certainty is not just unnecessary and unwise, it's unethical. It needlessly adds the worst kind of insult to the worst kind of injury, and I think the law should reject it simply out of decency. Thank you. That's my 10-minute summary.
Thank you so much, Hilary. That was just a beautiful summary of what is a beautiful book in a way. And I reread it for this occasion, and I was also struck there that what you've managed to do is take, I presume, a lot of insights from practice as well as from this, in-depth study of the case law, but also this great insight into the nature of legal reasoning, which you portray with great clarity and offer us this very hopeful conclusion that, law could fix at least some of this problem by giving better signposts to decision makers. So Gregor, I'm going to hand over to you for some questions to Hilary, and then I'll jump back in towards the end of the discussion. So thank you.
Thank you, Cathryn. Thanks for having me, and thanks, Hilary, for a great introduction to a great book. I've enjoyed it at least as much as Cathryn did, and I had to go all the way to chapter 8 to find some points where we are possibly disagreeing. Whether we actually are, we'll see in a couple of minutes. So probably I can start there, if I may. You have been in that chapter of your 2018 book, you've been usefully proposing to base assessment on abductive reasoning, as you just explained to us. And it looks for the best explanation instead of these thresholds of probability. And so you've built in a very well-explained step here between considering the evidence in the round and applying the standard of proof. You're asking for a crucial step to be taken, and if I may, I would just like to quote from page 198 of your book here. And I quote, "Throughout the hearing, a decision maker using inductive reasoning will be looking to infer from among all the relevant possibilities about what happened to the claimant in her homeland, the one that best explains what the decision maker is seeing and hearing. In deciding the claim, he will be looking to infer from among all the relevant possibilities of what might be awaiting the claimant on return, the one that best explains the totality of the evidence." End of quote. So if I understand that correctly, it introduces a different standard, namely that of the best explanation. And here's where I'm getting slightly doubtful, because I'm a little afraid that the best explanation standard opens a back door to standards which I think are irrational, namely the standards of coherence and plausibility as they operate in the UNHCR handbook, but also in the EU qualification directive. And by opening the back door to those standards, I think it's also opening the back door to the subjectivity of the decision taker, which we both acknowledge is there and needs to be there if things are radically uncertain, as Audrey McLean says. But we also want that kind of subjectivity to be on the show, in the open, so to say. We want it to be displayed with some transparency. And with the backdoor argument, I'm just thinking that, oh, is something hidden away in a different way here? So basically, on the technical side, I'm a bit afraid that abductive reasoning is introducing a set of second-order norms, which are displacing but not really solving the problem of determining how much evidence we need in any given refugee status determination case.
Yeah. Yes, that's a great. When I read your passage when your chapter in the handbook, it gave me so much to think about. So I spent a lot of time thinking about this question, and it's such an excellent question. And thank you, by the way, for introducing me to Professor Reyes Molina's work as well on second order norms. I hear that. I hear it. I think here's where I've gotten to in my thinking on this question. I absolutely agree that second order norms won't help to solve the problem of indeterminacy. So in other legal contexts, in the context that Professor Reyes is discussing, for example, the problem is that we don't know how to assess evidence against the standard of proof. So we don't really know what balance of probabilities or beyond a reasonable doubt means in practice. And so as I understand his critique, second order norms are just moving that question up a line without answering it. So if we draw on a norm to interpret beyond a reasonable doubt, then of course we have to interpret that norm. And it hasn't really gotten us any closer to figuring out what the quantum of evidence, how to assess that quantum of evidence. So I fully agree that there's that problem with using second order norms to address indeterminacy. The problem that the abductive model is addressing, though, isn't the problem of indeterminacy as I see it. The problem here, in other words, isn't that we don't know how to assess evidence against a standard of proof. As I see it, the problem is that we're using a standard of proof at all. And that's what's distorting the risk assessment function. That if a standard of proof is the point at which a fact is created, right, the point at which doubt becomes certainty, in a risk assessment, there is no standard of proof. There's no artificial preset point at which I know something to be true. There's only the risk threshold, right? Above this, too dangerous, below it, acceptably safe. Right? So in the mushroom example, for example, it's my threshold is simply, is it safe enough to eat it? And the problem with an inductive model, is once you start making those findings of fact first, then, and I sort of game this out with numbers in the book a little bit, you can end up accepting people who are at less risk than the people you're rejecting. What I'm thinking here is, you've suggested that this model might introduce a different standard. I would say that the legal risk assessment standard remains the same. The standard is still well-foundedness. So the risk threshold hasn't changed. The risk threshold is well-foundedness. What the abductive reasoning does is that it takes away the need for a second fact-finding standard, because it just takes us out of the realm of fact-finding. and into the realm of risk assessment. So put another way, to come back to the question, an abductive model, as I'm imagining it, isn't actually going to get the decision maker. It's not going to help them to weigh the quantum of evidence for the purpose of establishing factual propositions. So when I talk about Josephson's 5 considerations, he suggests you should look at how decisively the counter theory is surpassing the theory. In my case, how well it stands on its own. I think these are helpful questions for decision makers to be asking themselves in practice as they're going through this process. But it's not; these aren't a way to get to. It's not going to help them to weigh the quantum of evidence. In other words, it's not going to get them any closer to knowing whether this is a chanterelle or whether chanterelles are edible. It's not going to help them to make those findings of fact. What I'm hoping it would help them to do is to reason within the indeterminacy in a way that they need to if they're going to make a risk assessment. So in other words, it isn't about helping with the question of the quantum of evidence in the context of a standard of proof, as I see it, as I think it through now in the light of that very helpful question.
I think that helps me to understand the point you're making already in the book. And it also makes me realize that you're much more radical than what I thought you were. No, and I think I'm saying that with sympathy because in a way I think it gets us back to a point where your way of theorizing what is happening differently actually makes theory overlap with the empirical observations that have been done in quite a lot of studies at this time, which really emphasize that, it makes such a difference whom you are allocated to as a decision maker when you're an asylum seeker. So the kind of the personality of the decision taker is playing a huge role. And for one, if we assume that risk assessment and abductions are a way of explaining that, I would be the first one to say, yeah, let's try to see whether we can provide a kind of a theoretically informed description that actually helps us pick up what is actually happening rather than what is presumed or should be happening. So back from a deontological to a more empirical approach. So I think that's great. And I think there's a lot of hope in that. Now, if I may, I would like to move on to a related question. It's also taking its cue from your chapter 8 and the UK case of Cathryn. I hope I'm pronouncing this correctly, where you're suggesting that the judges there were basically put on track when reading that case. Judges should not draw these intermediary conclusions to dismiss evidence that is less probable as they work through the material. And you just explained it to us. And I think the way you put it is more sophisticated than in the way it is put in the UNHCR Credo study, which was a nice step in the right direction. But again, you're taking us a step further here. But again, I mean, the doubts I had when it came to the Credo study, I also have with to some degree when it comes to your model, where we're seeing that the judges are actually having this task of saving their impressions together with their doubts until the end of the day, and then taking a decision on that. And for us as human beings that are making the choice between, is this a dangerous mushroom or a benevolent mushroom, so to say, that might be manageable because we are capable of grasping the amount of time we put into mushroom picking, and the whole story of our afternoon unfolds before in our eyes. But it's very hard for in a collegiate setting to explain that to other people in a kind of a intersubjective way. So again, I'm concerned with subjectivity here, giving a kind of a shield to irrationality to a point where we no longer can communicate the true reasons that motivated us, unless we're having a single decision taker system which is very robust to being overturned on evidentiary grounds, and we probably don't want that either.
No, agreed. Mm-hmm. Oh, absolutely. No, and this is, I mean, this is right at the core, right? It's right at the heart of it. And I share this is the big concern, is that there is this irrationality, and subjectivity, and how can what can the law do to try to help with that process? And I mean, the first thing I would say, just abductive reasoning can't tame it. I mean, I think that the law can't tame it. I hope we can do as much as we can, but I think all of us who are researching in this area, we're also aware of how much doubt there is in this process, the radical uncertainty that Audrey talks about. But I know from our studies of decision makers that we often see decision makers don't necessarily see it as radically uncertain. Right? They're often very confident in their decisions, and they're often most confident in their credibility conclusions. And so, I think if our decision makers believe that they know a liar when they see one, we run right into the limits of what law can do. If what law is doing is telling them how to resolve their doubts, if they don't have any doubts, you know, we're right with that. That's kind of all we can do. But I guess what I think about when I think about it is, um, we I mean, first of all, we need good, careful, thoughtful decision makers who are not only open to being persuaded on the evidence, but also open to following the law's direction on how to resolve their doubts. Right? So they have to be willing to do that. We need them to engage with social science that shakes their confidence. So we need to have them challenge their assumptions in ways that bring some of that uncertainty to the fore. Right? And then we need a body of law that gives them clear, consistent, normatively hefty messages about how to resolve their doubts. Right? But then at the end of the day, as you say, in if that body of law is taking an abductive approach, they will be left with making this more complex decision in the final stage of the process. And so this is something, when I was reading these, I haven't a new study, I should say. I did a study recently where I was reading several hundred rejections from our refugee board, and coding them for the kinds of inferences that our decision makers are using when they conclude that someone is lying. So, looking at that reasoning. And as I was reading them, I was thinking to myself, what would this look like if it were an abductive process? So how would they be reasoning differently, or how would it be coming across differently in the reasons if they were using the kinds of processes that I've been talking about? And I mean, one of the things that struck me was that if what characterizes abductive inference, just exactly as you say, is the fact that you're carrying along all of your doubts until the end of the decision, um, in terms of how you're organizing your thoughts along the way, I think much of what you would be doing could be very similar. Right? So in an inductive model, I mean, this is obviously a sort of very pared down, but if the inductive model is it a chanterelle? Probably so, yes. Are chanterelles dangerous? No. Conclusion, therefore I can eat it safely. I mean, if that's the inductive model, the abductive version would be something like, is it a chanterelle? I think so, but I'm not really sure. Are chanterelles dangerous? Almost certainly not. Conclusion, when I look at the evidence in the round, I come back to my concerns about whether it's a chanterelle or not without being more confident on this point. I'm just not convinced that it's safe enough to eat. Right? Um, that final stage, as you say, is more complex, unavoidably, right? You have to do the work at the end, whereas in the inductive model, that conclusion is supplied by the algorithm, right? Therefore, I mean, it's just there. Um, so it is much more complex, and that's the simplest possible version. As you say, in a refugee hearing, it's a lot more complex. But at the same time, it's much more like how we actually reason, right? It's much more like how we actually make risky decisions. And so what I come to when I read these decisions is, I think it's more complex. I'm not sure that it's more difficult, because it's a more natural way of thinking, it seems to me. Um, it seems to me that what the decision makers are doing when they break it down into an inductive framework is they're taking some of that abductive work that I think they're doing naturally behind the scenes anyway, and translating it back. And so there have been in this, the scholars of abduction talk about how Wigmore, for example, one of the main theorists of evidence, right? Wigmore never uses the term abduction. He doesn't mention abductive reasoning. He only talks ever in terms of induction and occasionally deduction. But some of the theorists of legal scholars who write about evidence and abductive reasoning suggest that he is in effect recognizing it all the way through. That the way that he talks about legal reasoning is recognizing that that is what legal decision makers are doing. So my sense is that it is more complex, and structurally it's more complex. And part of the trick would be exactly as you say, the transparency. So how do you write it in a way that would allow you to do that work in the final stage and still have it be transparent on judicial review, for example? And that's something that I'm actually thinking about, and I'm planning to write about coming out of this study, is to give more thought to how you could structure an abductive conclusion in a legal format that would make it reviewable. Because, and I think this ties into your next point, which is I think really the heart of it, which is there more room for subjectivity there? So it is more complex. Is it therefore more subjective? And that's where I'm still thinking it through. But at this point, I'm not convinced that there is more room for subjectivity just because it's more complex. The reason I say that is when a decision maker says, is it a chanterelle? Probably so, yes. Or is it a chanterelle? I think so, but I'm not really sure. I feel like the subjectivity is more visible in that latter kind of conclusion. In other words, I think for all of the reasons that you and Professor Reyes have pointed out, the subjectivity in the former is there. It's just hidden in the standard of proof, right? It's hidden in that indeterminacy. And so I feel like, having frankly, the evidence for that, I think, is in our system. I mean, our decision makers are making decisions using that balance of probabilities, civil standard of proof. And using that civil standard, they are able to reach either conclusion on the same facts at will. So it's hard for there to be more room for subjectivity than that. Yeah. But it's all really important stuff to think about. And I'll confess, I don't, it's all kicking around in there.
Yeah. Thank you for those just incredibly thoughtful answers. And those are such probing questions. One thing I wanted to come in on is about the institutionalization of this model, because you've very much in your work focused on, a very apparently highly functioning individualized system where you have the trained decision makers, judges, and so on. And in the RefMig project, a lot of the time we're studying less formalized systems, in particular ones where there's a lot of group recognition, or whether formally in the form of prima facie or informally where UNHCR generates strong presumptions of inclusion for certain caseloads, as they would call them. And I wondered about the relevance of your account for that sort of determination that's made at a higher level of generality based on the facts about country conditions, and where a system sort of says, look, we know, given what we know about country conditions in South Sudan or Syria, that people fleeing from there now have a well-founded fear. And so do you think that your model speaks to that, or is it really about individual decision makers?
Oh, absolutely. That's a great question. And I'll confess, what I've learned of the group determination, I've learned from you and Professor Abdelati, and it's new to me because my background is in the individual decision making within the Canadian system. So it's something that I find very exciting, because what I would come back to as a refugee lawyer at least once a week is, why are we doing this at all? Why are we? This whole thing's a house of cards. It is so uncertain. There's got to be a better way. And when we look up from our individual system and look around, the better way would seem to be a group-based decision making when at least when you have state actors. And I guess that's the point where it hasn't ever clicked with my client base, because my clients were typically domestic violence, occasionally sort of guerrilla groups, but often non-state actors. But in the context in the context where it would work on the country conditions evidence, yeah, absolutely. I mean, in that case, that normative answer, the answer that says it is a better mistake to accept someone than to reject them. I think it's at the heart. It's the heart of that. The determination that you would be making based on those country conditions is still going to be a determination that it's a risk assessment. It still has a lot of doubt at its core. You have a different kind of evidence. You're dealing with a different sort of a different landscape evidence-wise. But I think my argument based on international refugee law, that this is coming right out of the convention, that it is something that we ought to be recognizing each and every time we're making a refugee status decision, that it would apply just as well.
Yeah. I think there our scholarship had sort of similar starting points, which is really knowing what we know about the levels of variation within and across asylum systems. Why do we do it this way? And I think, in your case, you found an account of legal reasoning that helps a lot if we keep that system in place. And I've been trying to think through alternatives, at least for some refugees, where their predicaments can be kind of categorized and where the facts really do speak for themselves. I know you, Hilary, have an exciting new project on AI, and I think that was where Gregor was going to come back in, because there too we have this shared research interest. And indeed, Gregor, did you want to pose the final question to Hilary?
Oh, that's generous. Thank you very much. No, I just wanted to know, what's your take on AI and refugee status determination? Could AI facilitate the establishment of the best possible explanation of the totality of evidence in RSD? Because we're talking about, now it's suddenly moving across a scale of risks that would be open to numeralization, and AI thrives on numbers.
Yeah, absolutely. Well, so my take, and I've looked at this with a colleague who is an AI scholar, so I'm the law half of our law and AI two-headed monster. Our sense coming out of the look that we took at it was that, yes, in theory, but if and only if the law changed radically. So coming out of the point in the book, in other words, if one of the central benefits of AI is that it can make uncertainty visible, right, which it can. So our own decision makers will look through this stack of country conditions information, come to what is a really very uncertain conclusion, but hold that conclusion very confidently. An AI would look at that material, come to a very uncertain conclusion, and say transparently, this is a very uncertain conclusion because we can quantify how much information is missing. And if that uncertainty hurts the claimant, as it now would, because they have the burden of proof and the standard of proof is, proof on a balance of probabilities tips against them, then that uncertainty is only ever going to hurt them. If we had a legal framework that does what I think it really needs to do, which is very clearly and firmly resolves doubt in the claimant's favor, then the more we are able to show decision makers how uncertain their predictions are, the more that should benefit the claimant. The more it would if the law did what it should. So in a nutshell, that was our argument in the paper, is that if we had a legal framework that resolved doubt in the claimant's favor, then an AI that helps to make that doubt visible would help. We also bracketed this off, by the way, to say that it should never be used in a credibility assessment. It should never play a role in a credibility assessment, and it should never be directed for ethical and legal reasons towards the final determination. So we should never have an AI system that says whether someone's a refugee or not, or says whether they're lying. But whether an AI system could say, for example, if the decision maker is willing to accept that the claimant is at risk from her husband if she returns home, and the question is, how are the police likely to respond to this? Will they take it seriously? Are they going to, how effective, how adequate will their response be? That's the kind of question that at the moment is answered by some human being's best ability to scan hundreds of pages of information, and that a computer in that system, computer-based learning model may be able to come up with a better answer.
Great. I think we have to leave it at that. Thank you very much.
Yeah. Hilary, thank you very much. And it's exciting to hear that you're working on this topic as well. And of course, it's so fraught with its own risks that, a role for AI, which is actually a targeted one to actually nudge decision makers in accordance with certain presumptions, or highlighting, as you said, the uncertainty of the predictions that they're inclined to be overconfident on, I think is both really useful, but also really useful to reflect on the kinds of automation that tend to be under discussion, that are so crude and really do replace human decision makers without thinking through the problems with human decision making at all.
Yeah.
So I'm delighted somebody with your insights is also working on this topic. This makes me want to keep chatting about the book, but I think the aim of this session was really to showcase the work, and I think we've done that beautifully. And Gregor, thank you for those probing questions that I can tell Hilary got a lot out of reflecting on as well. If anybody hasn't read it, you should. It's been very useful for us in the RefMig work, particularly in grounding very clearly this idea of the relative risk of error and how that has to condition legal decision-making around refugee issues. And I think in that respect, it's been a really useful work for us to be able to use as a premise for some of the additional empirical work we're doing. So thank you for the book. And again, thank you for your time, Hilary, again today. And Gregor, as ever, it's always a pleasure to hear and engage with you. So thank you both so much. And
thank you very much. Thank you very much for having me.
Thank you.
Such
Thanks
an honor.
both.
Thank you.